Yeah, we left off at we were starting with adverse, right on 5.03.
Yep.
So
Okay. Well, this could be pretty boring and dry. I definitely want your guys' help because this can get a lot of fun too if we all jump in and start discussing it. I know we all have opinions on it. Our states have um, differing laws and ways to approach this. So I definitely want to get a group discussion going. And without Jeff here, who definitely comes in and helps discuss some of this and brings light to his book, I definitely want your guys' help. So, adverse possession to me is one of these really interesting terms that I think we get drawn into probably more than what it actually occurs. Because it's kind of cool. It's like this way of stealing land because we're openly and notoriously occupying something that's not ours, and it's kind of fun to talk about. And the court cases can get kind of heated, and so I think we end up talking about this and give it a lot of time in classes or conferences. But it is something important that we need to recognize what it is. And I'm going to start by jumping over to. I'm going to jump way ahead here. Where did I have it marked? Oh, I just lost
going with
my
the
marker for it.
elements.
Um, but it he says in the book here, and what we need to recognize is when we're doing surveys, whether it's adverse possession or acquiescence or some of these other things that we're going to be talking about today, we need to recognize our role as surveyors in that is we are either hired to do kind of one of two things when we talk about boundary retracement. The first of which is straight boundary retracement. We are taking a deed, we're putting it on the ground, and we're going to note any discrepancies on that between the deed and the ground. And some of those discrepancies could possibly be caused by, say adverse possession. So we have to be able to recognize the parts of adverse possession. Or as a retracement surveyor, we might be asked to do more of a forensic survey of it. We believe there is adverse possession or acquiescence that might go there. So we're hired then to go look and identify the limits of that possession. But either way, we need to understand how our states look at adverse possession. So just as a quick poll here, what what do your guys' states say? Do you know what your statutes talk about when it comes to adverse possession? Anybody?
I'll go first if nobody else wants to.
There you go, James. I love it. I love it.
You can always call on me. I got something to say about everything.
You do amazing.
Uh, Adverse possession in probably every state will have about the same elements that have to be uh, in place before adverse possession will ripe. Uh, the time period that it has to run varies a great deal. In Arkansas, it happens to be relatively short at 7 years. And when you look at it and you read the books and they put down the different elements, it seems like such an easy, simple thing to contemplate. But in reality, it's not. And here's the kicker. Whenever you start looking at these things, whether a landowner has accomplished all of the elements of adverse possession, you find out that it's his actions that that fulfill those elements, but it's never single act action on his part. It's over a period of years. And so some of his actions may fulfill one element or several of the elements of adverse possession, but then a separate action that he took on fulfilled other elements. And so you get into a situation, if you take it by each action of the landowner against his neighbor, there's not going to be, he may be that there's not any one thing that he did that satisfied all of the elements. But whenever you take into consideration the several actions that he did over the years, they do complete that. All the elements were done, followed. So the question becomes, do you take those actions one at a time and they either fulfill the requirement or do you take them in aggregate? And in Arkansas, they take them in aggregate. And that's probably the way it is over the country. And that's, to me, causes a problem. And then
What's the time frame there for you guys?
7 years for us. 7 years.
And that's what it is in Utah.
Nevada's 5.
5.
Yep.
Well, you get into a situation where a landowner, if you've got small, I see this a lot. You've got small lots out in a semi-rural area. Somebody decided they could make some money if they divided their property up into lots. And they did so. And they sold some of them. But a lot of those lots didn't get sold. And they're not real big. Few houses got built out there. And it's been my observation in surveying, when you have houses that are built with the house be closer or approximately 10 feet from the side boundary line, if that adjoining lot is outside of the city that requires that undeveloped lot to be maintained, in other words, grass mowed, bushes cut down, whatever, then it grows up over a number of years. And the adjoining lot that's been developed that has a house on it, that landowner is going to go, he's going to cross the boundary line and he's going to do some action on that adjoining lot. He's going to cut the brush. He's going to start mowing grass down. If it's forested, he's going to start raking the leaves, because if he doesn't, it's a fire hazard. It promotes vermin and wildlife out there, that snakes, whatever. He's almost pressured to go across that lot line. And if you couple that actions over the years with an element that is there permanently for 7 years, and it just happens to be something that's not very easily seen, something that's down on the ground. Let's say a lot owner puts his lawn irrigation lines out there, and the pop-ups are out there, and he's 2 foot across on the adjoining lot. Well, that lot owner doesn't have a house out there, and he won't visit it very often. And if he does, he's not ever going to see that guy got across the lot line out there. But that satisfies one element of being there permanently for the 7 years. It's continuous. It satisfies that element. If some of the other things that he's done, and I've seen where lawsuits had uh, where adjoining loaners, lot owners stored firewood across the lot line, or they planted an apple tree across the lot line, or they took some other actions, or maybe they, uh, I don't know, just hundreds of different things that they could do that would be uh, intermittent, let's say. But if you take all those things in aggregate, by golly, you get a court that sometimes is going to rule that it's adverse possession.
Yeah. Well,
And
let's go through the list here real fast, and
Yeah.
let's. Matt's had his hand up, and then let's go through the list of those items you're talking about, James. So give Matt a second here. Go ahead, Matt.
Trent, I was just going to say that in California, we have it codified under our Civil Code of Procedures, and it's 5 years here, and it's very similar also to prescriptive easement, minus the taxes having to be paid for 5 years, and that's come up recently in a court case, in a Supreme Court case in the last year here. That a prescriptive easement cannot result in an exclusive use situation because it would be tantamount to adverse possession without having to pay the taxes. That that's a court case that just came out recently. That's kind of a little bit off topic, but I just wanted to point out that in California it is codified in our Civil Code of Procedures.
Okay.
And that's
you.
where I was going to go along that kind of same line, especially as more GIS and more counties start to build GIS. How, before always paying the taxes has always been the issue and probably the hardest claim when it comes to adverse possession. But as we roll into more GIS based systems, that's going to be an interesting claim when it comes to paying the taxes on an adverse possession claim. So I'm curious to see how that plays out over the, next 5, 10, 20 years or whatever the case may be. So,
Yeah, I think what happens and what a lot of counties here have done, not all of them, but they have the splash screen, right? A disclaimer.
yeah,
So that I think that's going to be the protection for that, right?
right.
Well, that's what I'm paying taxes on because that's what the county says I'm paying taxes on, but
Exactly.
versus what you're actually surveyed paying taxes on or an actual area.
Yeah. And there was a couple of things in the chat really quick. So Dean said 15 years in Virginia, 25 if the owner losing the land is medically disabled. Like I said, 5 years in California, Minnesota is 15 years, 10 years in Washington. So it's definitely kind of all across the board, but wanted to catch up on those.
Thank you. I lost my chat screen there for a second because I pulled up. So in Utah, can I share my screen, Trent?
Stop and good.
Okay. So Utah, if you ever, and your states may have this as well, but our state ombudsman has actually put some pretty cool presentations together. Am I sharing that right screen there? I've got too many. It's
No.
the Utah Commerce one.
No. Oh, there it goes. Yep, you're up now.
Okay, so this is the Utah Commerce site. It's a state property rights ombudsman, and so I assume every state has some sort of similar position there. But these guys are the advocates for the private owners, right? So they're there to answer questions, and property rights becomes one of those. And so they've actually put out a great little how-to about property rights and adverse possession in Utah. And so what does adverse possession mean? What constitutes adverse possession? So they quote the law here. What is considered possession or occupation of land? So if the claim is based on a written instrument or judgment purportedly giving title, then possession is established if the claimant does not at least one of the following: cultivates crops, encloses the property with a fence, uses the property for agricultural uses. If the claim is not based on written instrument but on another claim of title, then possession is established performing one of the following: substantial closure, cultivation or improvement, or at least $5 per acre expended on irrigation improvements. And it goes through how is legal title then established on adverse possession, which we'll talk about here. Is there property rights that cannot be acquired through adverse possession? Any land owned or held by government entity and designated for public use may not be acquired through adverse possession. Lands owned or controlled by the state or federal government also may not be acquired by adverse possession. And then a few cases here in Utah. So that would be another great resource that I don't think we've ever talked about in our Wisdom Wednesdays. That your states may actually have this information out there, that this is a great source when I start meeting with landowners that where we believe there could be an adverse possession case there, evidence of that. We balance this line between we are surveyors and we understand the law, but we're not lawyers. We establish the land on the ground and make sometimes legal determinations, but we're not lawyers. And so this is a great primer for Utah citizens that I'll actually point them to. This is, you want to learn what we're talking about. The state ombudsman page is a great resource.
Yeah, that's pretty cool. That's got a lot of information on there.
Yeah, a lot, and there's more than that. They go through a lot of different things there, legal topics, a whole list of them. Okay, and then getting into what TK said a little bit ago, and Matthew was too, under 5.03.1, it's the bottom of the second paragraph there. He talks about permissive uses, which would be easements, and so what he's talking about is probably unwritten permissive uses that couldn't then be construed as adverse possession. But the last sentence, permissive use never rises to adverse possession use and will therefore defeat any adverse claim. So if you've given permission and they've just overstepped their bounds, you've given some permission there anyways to kind of start that process.
Dean's got a good question. How do you get pulled into an adverse possession claim? My upbringing has taught me that surveyors only state where the boundary lines are according to record. And I gotta think, we are not to attempt to certify the ownership. If the owners question the ownership or the portion of the parcel, we refer them to a land attorney. So yeah.
Yeah, this is the hardest thing about all this discussion, Dean. And so I'll take my stab at answering your question here and my approach to surveying. But I just we'll open up to everyone else. But let's just go through the process of again doing a survey just as an example of how we would do a case. So you get hired to go survey a piece of property, and you do all the standard research that we've talked about, here at Wisdom Wednesdays and Mentoring Mondays and all our conferences. You pull all the adjacent deeds, you pull your deed, you pull any record as a survey, monument records, and you go out there and you set up your equipment and you go do a survey of the property. You locate the fences and the house and the occupation lines and the roads and right-of-ways and property corners and monuments and everything there might be, and you pull all that information then into the office and start drafting it up. And as you start going through that, let's just say for argument's sake that our client is being acquiesced against, meaning he's lost a portion of his property because the neighbors encroached over. There's a few things that I've seen surveyors do, and the problem is we are not the ones to make the determination on the face of the survey to say this is acquiescence or this is adverse possession, right? My approach to that is we'll pull out information together, and if there's no reason to confidently say that, hey, the property fits, but it fits off because of a tie to a section corner or tie to a monument, right? But you have what you're supposed to have, let's say 150 by 200 feet, right? Then we have we kind of hit pause on the survey and we have a discussion with the landowner. Like, did you know that this is where your property is and this fence seems to cut into your property? And we start this discussion of what they know and how they know that. I'm always careful to just say, hey, your neighbor's encroached onto you because it starts. Well, I've always known they're out over my line and I'm going to go sue them. We just start this as a very soft, I need more evidence here to determine where the property is. And then if at the end of your survey, everything leads to that this fence is not where it is, something's amiss, you kind of have to hit pause in my mind and say, this could be, I understand the law, I can recognize these elements, we can talk about the elements we're getting to, but there might be a case here to delve further in outside of your survey, but a legal case to then contemplate there.
We have exact same issue going on right now. It's a mountain area. There's known problems up in that whole area, but our particular couple of lots that we're working with had double back corners, and all the fences were built to the wrong double corner. To the point where one of the decks is like 10 feet over the property line on the house and that kind of stuff. And so we're in the same situation where bringing them in, they're coming into the office to discuss what's going on, but it's one of those situations when you have those double corners in the back, been mutually agreed upon corners, private corners, right? So this will be an interesting one as well.
So the question there is probably more of a discussion of perhaps acquiescence, right? Versus adverse possession.
Exactly.
But there's always this balance as professional surveyors of, I do not want to be the guy that pushes my client to go sue Happy because I've just blanket said, oh yeah, look, they're encroaching onto you. I always approach it with an air of, I'm missing some information, I'm missing some evidence. What else can we find? What else can we discuss? And then the next step is just like Trent said, is let's pull it in and let's try and mediate it. Let's have a discussion. Let's bring everyone in a neutral place and try and have a calm conversation about the next steps and what might be there.
I like that. That's where John Stahl's, taught us so much when it comes to both mentoring and wisdom conversations, as being that mediator and not just proving the facts that they're all wrong, but it's resolving it before it goes to $100,000 in legal fees.
Yep, absolutely. So let's try and answer Dean's questions a little bit more fully. So jumping over to the next page here, the book talks about this Strickland versus Marcos, and I'm going to read this first paragraph here. And this is a case in Alabama. So essentially, there are two forms of adverse possession in Alabama. First, adverse possession by prescription, and second, statutory adverse possession. So statutory means it's been written into our state codes or statutes. And so that's very clearly defined what constitutes adverse possession. So in the case of Utah and some of these states we've talked about, it's written into the code. We know about it. Where prescription is possibly through the courts or some other method there that it's become a common law type of standard in that state. So adverse possession by prescription requires actual, exclusive, open, notorious, and hostile possession under a claim of right for a 20-year period. So Alabama is saying 20-year for this this prescription style of adverse possession that they're talking about. And then these items here, actual, exclusive, open, notorious, and hostile, those are the key words that you're going to see in almost any state code regarding adverse possession. And it's what James was talking about when he was giving his examples. So statutory adverse possession requires the same elements, but the statute provides further that if the adverse possessor holds under color of title, has paid taxes for 10 years, or derives his title by descent, caste, or device from a possessor, he may acquire title in 10 years as opposed to 20 years required for adverse possession by prescription. So what it's saying there is if there's some sort of document, color, title, or taxes that are involved, it actually lessens that time. And that's, I think, a unique one. I don't know that I've ever seen that quite written that way in any surrounding states there. So that would be one to ask Jeff about. I'd be curious to know more. So then he goes through and defines what all these are. So this helps us give answer to Dean's question, but also gives us clarity to say this is likely an adverse possession case. So the first one is open and notorious. So it's not hidden. Open and notorious possession are essential elements of adverse possession because the landowner is thereby afforded notice of the adverse claim against his land. Thus, to satisfy these two elements, the claimant must provide evidence tending to show that his acts of dominion and control over the property were of such character and distinction as would reasonably notify the landowner that an adverse possession claim is being asserted against his land. I'm going to use James as an example. I think it was a great one because it seems pretty innocent here. But a rural landowner that might be up against a farm field or a forested property, and to protect his own claim, he's almost forced to, if you will, from what James said, go outside of his property, right? I'm going to mow outside of it to keep the weeds down so I can keep the vermin out of my property. I'm going to trim the trees and rake the leaves so they can I can keep mine clean, or put up some sprinklers, some lawn irrigation, and you go outside of the property. Well, in putting, and I'm just going to say this, it is what it is, but by putting sprinklers outside of your own property, if a landowner was there and present on his own land, the act of seeing sprinklers put in, installed, used on my property or outside, someone else's property, that gives due notice to somebody that I've encroached off what I have rights to. There's not necessarily an obvious one. It's not very clear to see versus, a fence that's clearly off the property. But that is, as I read that, reasonably notify the landowner that an adverse possession claim is being asserted against his land. Pretty obvious that something's come outside of the property. Go ahead, Matt.
Thanks. I just wanted to mention in California, it's actually a requirement to have it enclosed. The area to be obtained has to be enclosed to meet adverse possession.
Wow.
So we actually have to fence it off.
Okay.
That's a big one.
That is. That's definitely tough to get around. The next one is hostile possession. Another essential element of adverse possession relates to the claimant's intent as to assert dominion and control over the disputed property. Possession is hostile when the possessor holds and claims property as his own, whether by mistake or willfully. And so there's kind of a distinction there in my mind. The mistake portion of that tends to lead me down an acquiescence, right? I just didn't know, but in light of everything, right? You check all the boxes, whether it was mistake or willfully, you were adversely possessing outside of your legal deeded right. And then continuous possession. To satisfy the element of continuous possession, the claimant must prove uninterrupted possession for 10 or more years. Within the context of continuous possession lies the doctrine of tacking. That doctrine allows an adverse possessor to add or tack his time of possession onto that of a previous adverse possessor. So let's say it's 7 years in, they sold the property, someone new moves in, well, the clock starts again is what that's saying. You can't tack your time onto the back end of someone else's adverse possession. His time of possession onto that of a previous adverse possessor in order to reach the required statutory period. Before tacking is allowed, however, it must be proved that there exists a sufficient nexus, often called a privity, between the successive adverse claimants. This term privity is defined in Black's Law Dictionary as a mutual or successive relationship to the same rights of the property. Ballantyne's Law Dictionary defines privity of possession as a continuity of actual possession as between prior and present occupant and the possessor of the later, succeeding the possession of the former under deed, grant, or other transfer or operation of law. So biggest thing is it's got to be continuous. It can't be uninterrupted. That property line can't move back and forth. There's a really famous case in Utah of adverse possession and acquiescence. And we quote it all the time, but if you actually follow what happened after this court case we always quote, adverse possession happened or acquiescence was shown to have happened, but then, after the courts had resolved it, subsequent things happened that negated what the court had, and so they moved that line back and forth over time, which changed the outcome of the way that court case is now used. Exclusive possession. Exclusive possession is generally demonstrated by acts that comport with ownership. These are acts as would ordinarily be performed by the true owner in appropriating the land or its avail to his own use, and in preventing others from the use of it as far as reasonably practical. So it needs to be just yours. You can't have two people possessing over the same area, and maybe it could be two adjoining neighbors that are using a third person's property, but if those two neighbors are using the same area, it's not exclusive. Does that make sense? And so those are some of the main things we usually see when we talk about adverse possession there. The kind of these check boxes to help us give evidence and light to it.
There was one in the chat from Aiden, but color of title always required on adverse possession? So,
and that's probably a state to state thing. I'm not quite sure on how to answer that, other than probably it's going to differ state to state.
Agreed.
Well, in Arkansas, you have to be either have color of title for what you're claiming adverse possession to, or you have to be an adjoining owner with color of title to an adjoining property. And because what's changing there is the boundary line, and that doesn't change what your deed is until it goes to court and it's affirmed as adverse possession has ripened into ownership. So for the tax purposes and whatnot, all you have to have is an adjoining property and the person that's paying taxes on that piece of property. Across the line, you can still go forward with adverse possession. Now, the taxes come in when, if you pay the taxes on the adjoining piece of property that you're claiming under adverse possession, you have to have possession, physical possession, with all of the different elements of a part of it. But if you can show that you have adverse possession has ripened on a part of the property, and you have paid taxes on the whole for 7 years, then you are entitled to the entire property. In other words, the tax payment there is kind of a prima facie proof that you were in possession of the whole and not just a portion. And that's you can have a very small adverse possession, but if the taxes have been paid by the adjoining owner, he gets the whole thing. So it really gets complicated from one area to another. And this deal about whether you take the actions of the adjoiner in aggregate or each individual action is one that caused me to change my career in the 1990s, or about the turn of the century, because we had a court case in Arkansas that went all the way to the Supreme Court. No, I take that back. To the appeals court, and the appeals court had a split decision on that. It was a case like I had explained about, whether you had an improved property a lot alongside an unimproved property that had been there for 25 years, a situation. And the improved property had, in order to control the water on their property, it was slope property down to a lake. They had poured a concrete gutter that protected a driveway from water washing over it. And this surface drain, that concrete like a curb, like a gutter, extended onto the adjoining lot about 2.5 feet. That's what the court said anyway. They recognized that. The other elements that went into that were the developed property owner had uprooted a tree on the adjoining property. He had at times stacked firewood on that property. He had at one time stored some shingles across the lot line on the adjoining property. And he had occasionally cleaned up that area over there, especially where a garage was built close to the line. Well, the court decision that finally came down from the appeals court awarded him all of the property that he had had any possession of, even temporarily. They gave him all of the land that he had stored firewood on at times, the asphalt shingles, and the part that he had raked or whatever. Two or three of the justices said that the adverse possession should have been limited to the concrete that was visible. That was the only thing there that was visible and that remained there for the entire 7 years. But all the rest of it was wouldn't on its own. Those actions wouldn't have completed the adverse possession. And that type of thing, if you applied it to boundary lines all across the state, you would have adverse possession suits that would fill the courts with it, because it would. When you get in some rural areas, you will find that type of situation in maybe 30 or 40% of the surveys that you do. It was a terrible decision in my estimation, and so it robbed the value of an accurate survey, because you make a case for adverse possession in about 50% of the boundary litigation that goes on in our state now. Matter of fact, I would advise attorneys, and have advised attorneys, to seek a boundary for their property under the statutes or under the doctrine for adverse possession, because it'll sell to the courts most of the time. And if your survey, if a survey perfectly done of record title is not withheld or protect the landowner, his boundary, then you don't have anything that you could sell to a client. And that was what I came to. And I started changing my career. I said, I don't want to sell something that's worthless. And that's what it is. I hope it's better in your state. Most of it, from what I hear, it is. But be aware of that. You don't want to wind up like Arkansas, not if you're a surveyor.
Okay, thanks, James. Well, let's talk about that. We'll jump ahead. The book goes through statutory adverse possession. I think we've kind of blurred those lines a little bit in our discussion, because we talked about the prescriptive and what some of those elements are, and statutory. We've talked about the state codes. I don't know there's a lot of overlap between there, but if we go to 5.3, 03.4, it talks about adverse possession of the land surveyor. And so this is kind of what I talked about. There are two functions for the land surveyor when it comes to a case of adverse possession. First, the surveyor, like I talked about, may have been hired to survey a client's property boundaries. This is the primary function of the boundary surveyor. In the vast majority of cases, this is what the surveyor's client wants. In this capacity, the surveyor recognizes any adverse possession found and reports it to the client. And this is kind of that led us into Dean's questions. How do you get pulled into an adverse possession case? Well, this is one of the ways you recognize signs or those elements there. Continues on to say, however, adverse possession, no matter how obvious, does not change property boundaries because it can't until perfected. The second function of the surveyor in an adverse possession case is forensic in nature. The client knows about adverse possession claim, and the client or the client's attorney has hired the surveyor to survey the lines of possession and describe the possessed property for the purpose of litigation. And so here's the important thing, and this is where we get mixed up often as surveyors of the now what. I found this, now what? I've made a boundary determination. It's clear that the deed does not fit the occupation. And something has happened. We can talk about, and we will talk about acquiescence, and we're talking about adverse possession now. So the distinction between these two functions is that the first case, the surveyor is attempting to determine property boundaries based on a proper interpretation of the client's deed in light of all the surrounding circumstances. In the second case, the surveyor isn't trying to determine property boundaries at all. The surveyor is helping build a case for litigation. So our role is significantly different than that. And we've talked about litigation. I think there's probably some great Mentoring Monday there that talks about litigation as well. I'm going to keep reading this because I think it gives clarity to what I want to point out here at the end of this section. He continues on, this is not boundary surveying as described in he quotes the 2011 ACSM standards. The boundary lines and corners of any property being surveyed as part of an ALTA land title survey shall be established or retraced in accordance with appropriate boundary law principles governed by the set of facts and evidence found in the course of performing the research and survey. This type of survey is akin to a forensic survey, and no monument should be set on the lines of adverse possession until the what is changed to match the where. And this is the important part, by court decree. Anytime we're dealing with this, and I've seen it on surveys where they'll hatch that out and they'll draw lines through there and they'll say area of adverse possession, and they might even write a new deed on the survey. And when we talk about adverse possession, Jeff has consistently talked about the what's and where's, right? What we're surveying is the deed. The where is putting the survey on the ground. And we can't change the what in an adverse possession case unless the courts do that. That is a court function to do that. In the most clear-cut cases, adverse possession will stand out in obvious contrast to an otherwise clear and unambiguous boundary. Until perfected by court decree, adverse possession is an unwritten claim that a conveyance has taken place outside of the deed. For the land surveyor to opine that adverse possession has ripened into legal title, in effect, is to claim that such an unwritten conveyance has been perfected. This is a deviation from the surveyor's primary role of interpreter of written conveyances. In other cases, adverse possession will not be so clear-cut due to ambiguities in the written instrument of conveyance and evidence discovered on the ground. In such cases, adverse possession could almost be indistinguishable from acquiescence or practical location, and we'll talk about those ones here in a little bit. So he finishes this off.
As the fighter jets go over your head.
Yep.
You can hear them while you're talking.
I'm about 2 miles south of the Southgate Hill Air Force Base here.
Exactly.
It's always fun. I don't even recognize it anymore. I just keep going. Excuse me. So Jeff finishes off this portion by saying, I'll restate my rule of thumb on ambiguities at this point. Generally speaking, if the deed is clear and unambiguous on its face, there are no significant conflicts with surrounding deeds. If the monumentation and other relevant extrinsic evidence in the field create little conflict, and if every other prudent surveyor in like or similar circumstances would place the deed where you are going to place the deed, then stake the deed. Sometimes a fence is just a fence, and an encroachment is just an encroachment. If, on the other hand, ambiguities abound and the deed is subject to more than one interpretation, the extrinsic evidence must be weighed and evaluated for a proper resolution of the boundary issues. This is when the boundary doctrines such as acquiescence, agreement, practical location, and estoppel may lend a hand in the surveyor's final opinion on the boundaries involved. I'm going to paraphrase what I hear from Jeff here, and to kind of finally answer Dean's question. How do you get pulled into an adverse possession claim? The evidence is so clear that you know where that boundary is. There is no ambiguities on how to place it. It is just blatantly obvious that someone has gone over their line. There's enough due notice given of where the property should have been, and it is just obvious that there's nothing in the deeds that says, oh, maybe the property line could have been over here or intended to be over here. No, the deeds and the evidence, the monumentation are clear, and someone is still off what their legal right is. Anything else then falls into acquiescence, practical location, and estoppel. So how do you get pulled into a boundary by acquiescence case? The deed's pretty dang clear. You know what it's supposed to be. Any other surveyor would pretty easily know what it's supposed to be. It's not a tough survey. And still there's an encroachment. Still there's someone over the line.
Well, I'd like to make one distinction here, and that is the difference between a conveyance and what record title is. Because I've had surveys that I completed that were based on record title that didn't look anything like the conveyance, nothing like it. But they were based on what the historical record title was. You could trace the title and explain why the boundary line was not what was shown on the latest conveyance. And I contrast that with record title with what is adverse possession, acquiescence, estoppel, or some other means where other than record title has changed or modified the ownership lines. And so I hope that everybody understands there that what we're talking about on one side is record title, not necessarily conveyance geometry. It's record title, and which involves all of the surrounding deeds, prior deeds. I've gone back 40 or 50 years and found evidence of where the line should be in an early conveyance, and then some fool made some cockamamie description for the same piece of property from a different corner that made absolutely no sense whatsoever with what the guy actually owned. So we do have that, and so I would caution everybody to make that distinction between what is conveyance, because what we're working with and what we put down there for ownership lines is record title. And it may not look like the conveyance, but it's still record title. And beyond that, I always showed on my surveys record title. If there was adverse possession, I showed that too. Sometimes I showed a element of encroachment or one to one side or the other, and I'll cover that in a surveyor's report to my client and make him aware that he is across the line, and he may have to give that up, or somebody else has encroached on him, and if he cannot get that person to recognize the property boundary line, he may have already lost that property. The one thing that you don't want to do is get your client into litigation, at least not in Arkansas, because when you go to a trial court, unless you've got the money that you want to put into an appeal, that trial court, you might as well be flipping a coin about your chances of winning. I got awful lucky, but that's all it was, luck.
Yeah.
And Dean kind of asks kind of what you're saying, what you show on your survey. So Dean follows up. Why don't you just identify that as an encroachment and not state adverse possession? And this is where I hit pause on my surveys. That survey is not done at that point for me until that's either resolved or gets to a point that it can't be resolved, and we have to file a record of survey just to give due notice. Again, Utah being a different state in the way we file surveys, it is an opinion filed in the county surveyor's office. But if we find something that's an encroachment that is likely adverse possession, we're having a discussion about what's next. What do you as the homeowner want to do? Do you want to protect your interests and try and get this person off your property so that they don't have a claim to it? And sometimes we'll file a survey just so it's in the record. Sometimes we'll wait as we work through this process, whether it's through mediation or some other course. So to answer your question, Dean, is I may not show anything on my survey other than for an exhibit's sake, and I'm not done with that survey until it gets resolved, till that record title through a court action gets cleaned up and we have something to put properly into the record.
And I think, and from an, if you go listen to Gary Kent as well, but I don't believe, and I would say early on in my career, we used to use the word encroachment, but we've gotten away from that, at least the word encroachment, and we'll just list maybe some deltas that a wall maybe off of a property line or something like that, but we don't say encroachments. And I believe, and I might have to go back and see if we can get Gary to maybe do a whole mentoring on the word encroachment, because there is the legalities of the word encroachment when you start to put it on your surveys, right? And so we've started to list things as area of concern, or just different deltas as they relate to property lines and stuff like that, and definitely gotten away from the word encroachment, because that from a Black's Law dictionary or anything, the word encroachment can be construed as so many different things, and so it's actually a pretty powerful word when it comes on our surveys. So
Yep. Yeah, I do as much as I can. In fact, I just walked a property right before I came back to Wisdom Wednesdays here, of a survey I did just a couple of years ago. The fence is, it's like 500 feet long, and it's about an 80 feet by 500 foot
yeah,
long property. It's horse property. So that fence does this. And so as I shot that fence in different distinguishable areas, I have, at the beginning of the fence here at the south end of the property, I'm 1.1 feet off the property line with the fence. As I get up here, the fence is on the property line, on the property line, and it jogs with a pipe fence, and I'm as much as 2 feet off. They're doing construction next door. The interesting thing with this one is there was a survey to the west where they're now doing development. So I actually honored their survey. They found the same evidence. That survey did not show any improvements on the land. It was just deed lines, so there was no perspective on where that property line fell in regards to the fence. But now the construction guys are out there and they're just building stuff. They see the fence, they assume it's the property line, and they've encroached over into my client's property. So we went and walked it this afternoon, but I didn't call that encroachment or overlap or anything. It was just, here's where the fence is, here's where the property line is, and then in my narrative, I referenced the property of the neighboring survey that, and property that's now under construction. So
Harmony's got some stuff in the chat too.
a road or trail for San Antonio Park has been recorded over her land. Is that record title? Am I supposed to go searching for newly recorded surveys? The road is even with the Texas DOT. So the couple questions I would have, Harmony, for you. You just put, they did that to allow adjacent property a way to get to the highway. So there's a couple things there that you might have condemnation, or what's the other term just left my mind there, where the cities have the right to come take the
Eminent domain.
eminent domain, right? Where for the overall good or project, they can come take a portion. And so without getting too much into it now, generally speaking, any eminent domain or condemnation cases, they still have to pay market rates for those properties that they take. They can't just take it and not compensate. But there's two things. So a survey, and I don't know how it is in Texas. There may not be a survey per se over your property, the adjacent, because it could just be a deed take or a construction project that's necessitated that. So that's a tough one to answer. But I mean, you should be given due notice if they've taken a portion of your land, because they should be negotiating with you before that.
We need to we need to find Harmony a San Antonio surveyor just to do some pro bono work for her because
Yeah.
she's been tagging along for the last year about all of the problems she has with her property, and we've yet to find her a Texas surveyor that wants to.
Surveyor.
Exactly.
Yes on here. So
Harmony, I got a friend that lives in Austin and she just had a baby, but maybe she's got some time to at least do some little bit of local Texas research. So I'll shoot you an email tomorrow, or you can even shoot it to me tonight, Harmony. Just shoot me like your APN number or the address of your particular property. And I know you've been battling this for a long time, so
yeah.
And you join us every week. So just to learn, right? Because you want to have your power when you do get to talk to somebody someday. But
yeah, well, that's exactly it. Harmony. The case I went to this afternoon before jumping on here is very much the same way. It may not be the state, but a private developer that's, by all means appears to be bullying their way to get what they want. But It's always nice to have an advocate on your side. So, and that said, I'll say that surveyors should be neutral in all their decisions, but it is good to have an advocate once we make that determination and help support that. So Dean threw back in the chat, we identify them as possible encroachments and try to avoid causing legal issues. We are afraid of lawyers.
yeah, exactly. I love it.
Yeah, that's we don't do possible encroachments or encroachments either. We take that same approach. We note it as is. So great discussion here. We're rolling through this and still have plenty of chapter to get through. So boundary by acquiescence. Let's jump into this and keep moving here. So the boundary establishment doctrines all operate outside the statute of frauds because they are not, technically speaking, a conveyance of land. So when I talk to clients about boundary by acquiescence, my layman's simple term of putting this is no one knows where the property line is. We've all mowed up to the same line, and by mowing to the same line, we agree that this is the line, so now it becomes the line. The challenge with that, just like adverse possession, is it doesn't fall under the statute of frauds. It is not a correction of title if a correction needs to happen, and it is not a conveyance of land until something perfects that. And so in Utah, we have a boundary by acquiescence portion of our statutes where you can, file a record amount or a record description for the line that you guys now agree is the line. And it is clearly described that it must be unknown. It can't be in dispute. It can't be reestablished by any other means. And then the landowners, which is their right, can then decide on a common place to put that line. But acquiescence, the idea is we've by our actions agreed to this, and it may be in doing nothing, but we agree to this in our inaction, which ends up being an action. He says in here, the Delaware court went on to explain that once boundary lines have become established by way of these boundary doctrines, they remain settled on successors in interest. So it's important to know is when these are resolved, it's forever resolved, right? The next homeowner can't come in and say, well, we don't know where this is, and upset the apple cart again, as it were. He says here at the top of 148, before we get into this next court case here, Every state that has adopted the doctrine of acquiescence has adopted it with its own set of rules and standards. It is incumbent upon the land surveyor to know and understand the doctrines as it has been established and applied by the state within which the surveyor practices. An Arizona case is directly on point. In the case of Mealy versus Arndt, the Arizona courts considered for the first time the elements necessary for boundary by acquiescence. In doing so, the court reached out to the law in Maine, North Dakota, New Mexico, Washington State, South Carolina, Utah, Arkansas, Florida, Texas, South Dakota for guidance. It says listed in order of appearance. I don't know why Arizona went to Maine, the furthest state away first, but there it is. He says this case is also an interesting case on the subject of original monuments set by the original subdividing surveyor. Normally these are considered sacrosanct. Observe how the court treated them in this case. So before we jump into this, I just want to kind of get the quick straw poll. What are your state's requirements, if any, or codes in regards to boundary by acquiescence? Do you guys have any guidance there in your states?
In Arkansas, we have boundary by agreement. Boundary by acquiescence is considered by the courts to be is essentially a boundary line agreement expressed by the actions of the parties, and it's kind of difficult to prove. You don't see the courts deal with it a lot. It's a last resort for the court to rule on boundary by acquiescence. Now, a boundary by agreement that can be proven by writings that have been put into the record, or even writings between the two adjoining landowners, or a fence that both pay for that's built upon a boundary, that's something that would put a subsequent owner or buyer on notice that these two landowners have effectively set their boundary. That you can take to court. But just because a mold line is out there, and both of them have been kind of using it this way, that doesn't really put a buyer on notice that a boundary line agreement has occurred, and it may not stand up in court, not in Arkansas.
So to clarify, in Utah, and we're about to change our language, we've been working over, it's been a number of years, but we've really made some headway the last year. We've got as soon as our session starts up here in a little bit, we'll have some code updates introduced that talk about boundary line agreements and boundary line adjustments, which is just, boundary line adjustment for the quick of it is, they know where the lines are, they want to adjust it. Someone wants to build a garage and needs an extra 5 feet, so they're going to adjust boundary lines. But boundary line agreement, I think they go hand in hand in the way we approach them with acquiescence, right? Acquiescence is the unwritten agreement of a line, right? We don't know where it is, we've acquiesced to it, we've both by our actions agreed to it, but then to perfect those rights, to update and correct title, then there's some sort of boundary line agreement that needs to happen and be filed or recorded with the recorders or register of deeds to actually change title. And so that's what the boundary line agreement is. That's kind of what James was talking about as well. In the updated code, I don't remember what the term is we're not actually going to use the term boundary line adjustment, just because adjustment and agreement are so similar. So we're going to, they've got a new term that they've coined for this. Matthew says, I'm not aware of codified acquiescence in California. We have boundary by agreement, which seems like it might be the same thing, but again, I'm not aware of any state code on it. And Kyle added, in California, if you acquiesce, that's super, but you need a lot line adjustment to comply with the Subdivision Map Act, I think.
I agree. I agree with Kyle on that one. So, and then Nevada, we only have boundary line adjustments. We don't have boundary line agreements. It would be a court decree if you're going to just do a, that kind of stuff. But a boundary line adjustment is up to the jurisdiction to even allow it at this point. So, and it has to be less than 10% of transfer area as well. So 10% of the parcel square footage has to be less than 10% of that for boundary line adjustment. So otherwise, we're doing amended parcel maps, amended final maps, amended, this, that, and the other. So
yeah, so we've approached it a multi-pronged one. So on boundary adjustments, again, that's where the property line is. You have a reason to go move property lines. That does need to be approved by the whatever jurisdiction it is. Make sure you meet zoning, frontages, setbacks, and all that type of stuff. But the boundary agreement or boundary by acquiescence, the way the law is interpreted here is, well, that's always been the line because that's where we agreed it is. We've never known where the line is. So it's kind of forward and retroactive. And so there's not this approval process for it, but we're clarifying what documents need to go in there. And I'm giving the 10,000 foot version there. Teresa threw in the chat, acquiescence requires that the defendant stand by silently while the claimant acts as though the boundary line is the actual line for the period of the statutes of limitations, which is 15 years pursuant to Minnesota State Code. A classic example of acquiescence is when adjoining landowners mutually construct a fence with the intention that the fence represents an adequate reflection of the property line. Finding practical location by acquiescence when parties and their predecessors in title made a conscientious effort to build dividing fences as close as possible to actual boundary and remain satisfied with the fence's location for the statutory period. And so you're actually getting into practical location doctrine there as well, which we hopefully we'll get over to today. And then Kyle threw in boundary line agreements do exist, but require absolute uncertainty in the boundary line. John Scarpa mentioned that he has seen one in 30 years in Sacramento County. So interesting. Okay, well, I am looking at the time here, and I want to make sure we get through chapter 5.
got a long ways to go.
We got a long ways to go. I was going to read more of this court case, but let's, because there is some interesting things in here about original monuments. I think we've talked about a lot of that. So if you didn't read that, reread it, and we'll go from there. So jumping through the court case and jumping here just at the end of it. So I'm going to go up just a little bit more before we get to boundary by oral agreement. Just at the end of this, beside the issue of acquiescence, one of the really interesting aspects of this case is the fact that the original monuments set by the original subdividing surveyor were not honored. Why not? We have to do some reading between the lines to understand the answer. If you recall our discussion on court opinions that we had in the footnote to the Kerr versus Malden case in chapter 2, you will remember that these court opinions never answer all of our questions. They can't. They are opinions, in many cases just a few pages long, based on trial record that could be voluminous. The opinion is pared down to the essential elements by reciting some of the facts that the articulation of the law is based upon. Reading between the lines, in this case, we observed that the descriptions of the property from the survey were critically different than the descriptions contained in the deeds. How did this happen? In all likelihood, the original developer told his surveyor to divide the property on the ground, and he had his attorney divide the property in the deeds. Obviously, the two were never compared, and there's no mention of a map or plat ever being recorded. The surveyor divided the property by taking the road into consideration, and the attorney did not, resulting in a 20 to 30 foot discrepancy in the division line. The survey was probably handed over to the developer, who stuffed it in a drawer, and the deeds were recorded in the public records. And James kind of talked about that a little bit, the difference between all those. Kyle talked about this absolute uncertainty. The difference between the two creates a strong uncertainty there. So, boundary by oral agreement. In all our discussions, we've talked about we've talked about how little some of these oral agreements actually hold weight. The deed itself creates certainty in things. So closely associated with, and in many cases an element of boundary by acquiescence, is the doctrine of boundary by oral agreement. In most jurisdictions, the doctrine is relatively straightforward. Two landowners unsure about the true location of their common boundary can agree to a location that will settle the matter. Some states may require that a fence be erected to memorialize the line thus established. In other states, this may not be a requirement. Some states also add the caveat that if the true line is ascertainable, this agreement is voidable. As with the doctrine of acquiescence, there appears to be no universal rule on all of the particulars, and each state seems to have its own elements that are necessary for the doctrine to operate. So this gets into my approach to what we talked about to surveys and discrepancies between the deed and the ground. We go out there and we find that we're able to determine where the property lines are, and maybe the previous owners, they just didn't have the means or the money to go hire a surveyor to do it. So neighbor 1 and neighbor 2 shook hands, built a fence, called it good enough, and walked away. But neighbor 3 moves in and actually has the money to do a survey. He wants to change the fence, build some landscaping, add to his house, and he's going to pay for a proper survey. So now I, as a surveyor, come in and I can do a proper survey of it, and it's pretty obvious that, hey, this fence does not match the deeds. And so again, that's where I hit stop and see if I can't find any other evidence. Thanks, Dean. And so I might need to go to that landowner, the neighbor, and have a chat with him. Hey, did you know the fence you guys put up doesn't match? And that evidence comes to light, right? Oh yeah, well, we didn't know where it was and we didn't want to pay for a surveyor, so we just shook hands. We paid for half the fence and built it together right here. So he says, in Indiana, for example, described in the doctrine of boundary by oral agreement in the case of Piles versus Gozman, and linked to the doctrine of estoppel, Piles also argues that the trial court improperly found that the fence served as an agreed boundary line because the issue was not properly pled, and because it was based on inadmissible hearsay. Under this theory, when adjoining landowners agree to erect a fence and treat that as a legal boundary, they are stopped from denying that is the legal boundary. Use and improvement of the land up to the alleged boundary line may be sufficient to satisfy the requirement of agreement if the adjoining landowner acquiesces. This line agreement is not only binding on those parties who agree, but also their successors in interest, so long as there was no fraud present in the making of the agreement. And so I think that's the big kicker when we talk about this, the no fraud. It was done in good faith by both parties. Any questions about boundary by oral agreement as we keep rolling on here? Okay. 5.06 then, boundary by practical location. The doctrine of boundary by practical location is closely akin to the previous discussed doctrines of acquiescence and oral agreement. Boundary by practical location appears to be a niche doctrine that has not been widely pronounced. The Supreme Court of Minnesota in 1893, in a case of Beardsley versus Crane, laid out a basic definition. I'll just read the first part of this. It says, evidence of what is called a practical location of boundaries of real property is often competent in cases of controversy respecting division lines, and it is sometimes difficult to determine whether such evidence should be received or rejected. Where there can be no real doubt as to how the premise should be located according to certain and known boundaries described in the deed, to establish a practical location different therefrom, which shall deprive the party claiming under the deed of his legal right, there must be either a location which has been acquiesced in for a sufficient length of time to bar a right of entry under the statute of limitations, or the erroneous line must have been agreed upon between the parties claiming land on both sides thereof, and afterwards acquiesced in, or the party whose right is to be barred must have silently looked on while the other party acted or subjected himself to expense in regard to the land, which he would not have done if the line had not been so located. This is a lot here, but I might just keep going here. I lost my place here, not been so located. But to establish a practical location, which is to divest one of a clear and conceded title by deed, the extent of which is free from ambiguity or doubt, the evidence establishing such location should be clear, positive, and unequivocal. There should be an express agreement made between the owners of the lands, deliberately settling the exact precise line between them, and acquiescence for a considerable time, or, in the absence of proof of such an agreement, it should be as clearly and distinctly shown that the party claiming has had possession of the premise claimed up to a certain visible and well-known line, with the knowledge of the owner of the adjoining land and his acquiescence continued for a considerable period of time. What this period is has not been limited or defined, is quite vague and uncertain, and must necessarily depend on the particular circumstances of each case. It has often been said that this acquiescence must have continued for a period of time scarcely less than the prescribed by the statute of limitations, and in some cases it has been held that the doctrine that an express agreement recognizing an erroneous boundary line will conclude a party must rest, if tenable at all, upon the principle of estoppel. That's a huge mouthful there, but it just lends into a lot of what we're talking about and what we're about to talk about with estoppel. So the practical location means a reasonable location for that boundary line, all things considered. That's the simplest way I can kind of put that one. Again, to his own admission, there's not a lot there that's ever been used. He has to go back to 1893 to even find a case to kind of talk about practical location in the courts. And the final one here, I think this is our final one, is boundary by estoppel. And he's talked about this already some. So boundary by estoppel means that a boundary by estoppel is a legal doctrine that establishes a property boundary based on a neighbor's misrepresentation, protects the innocent neighbor from injustice. Is a simple one. So a neighbor makes a false statement about a boundary line. The innocent neighbor reasonably relies on the misstatement, and the innocent neighbor would suffer substantially an unfair injury if the true boundary line were enforced. The doctrine is based on the principle that a person should not be allowed to deny what they once acknowledged. It is designed to prevent fraud and injustice by protecting landowners who reasonably rely on their neighbors' misrepresentations. Any questions about estoppel or any concerns there before we jump on to, I guess that is it there.
Oh yeah.
I thought I had a little bit more on estoppel. So I'll just read this last paragraph here on estoppel. It says, estoppel is similar to the previous discussed boundary doctrines, rests upon an agreement implied on their circumstances as to the correct boundary line between the coterminous landowners. In the case of estoppel, the landowner wishing to deny his or her previous position on the issue or lack of action on the subject will be stopped from asserting a new claim or right. Stated another way, is a boundary establishment doctrine used primarily to defend against a prior inconsistent position. For the boundary surveyor, the landowner's previous position on the issue of the correct location of the boundary line in question may be very difficult or impossible to establish. However, as is clear from the Dickus case above, previous surveying work completed for a landowner that was subsequently accepted by the landowner is a strong indication that estoppel could come into play should the landowner later attempt to deny the survey. So these last few boundary doctrines, what's important to note, recognizing what they are and having understanding of the terms there, But more importantly is that's a stop point for our work. We recognize that there's something more than what the deed has, and the deeds must needs corrected in some way to reflect what is actually on the ground. It's not just we can go put it on the ground with a simple survey, and I can't say what that line is, right? Well, the fence is just a couple inches off, but it's been there long enough and they've acquiesced to the fence and we're good enough. Or the fence is 10 feet off and that's enough to say, hey, this is a boundary by acquiescence or adverse possession. That's going to be so case by case of how we lay that deed on the ground. But so much of what we talked about is gathering evidence, looking at it as a whole, looking at the adjacents, and seeing how that all fits together and making a boundary determination off of that. And then, if needed, informing our client of some next steps. But one of the most important things we can do, is not just put on our survey area of confusion, area of overlap, area of encroachment, file that survey and walk away and cause more confusion for our clients. Even though we're not attorneys, and we can't do that portion of the work, I truly believe we must kind of stop and inform them and say, hey, let's get this corrected. What can we do to work with your neighbor if needed to correct the record? Can we get a boundary line agreement, a boundary line adjustment, whatever your states allow, to then correct the record further going forward, so that there's 5 years from now, someone else isn't hiring another surveyor to go do it because the record's still bad, or someone else buys the property and they're not sure what they're buying because we've never cleaned up what ambiguities might be there. And so, if nothing else from this chapter here, is understand the different boundary establishment doctrines, and then understand your role as a land surveyor to then what's next. I've identified this. What do I do? How do I do that? And so that's going to be a little bit state to state. And then once that's fixed, then we mark that on the ground. We file a record of survey and whatever else might need to be done.
There's one thing I'd like to point out about estoppel. And normally when you read that, you think about a adjoining neighbor that said something that misled an adjoining owner in doing something that will cost him down the road. But not only is saying something, but silence also can lead to estoppel. Let's say that one landowner is going to build a fence or a wall or some other fairly expensive thing along the boundary line, and he goes out there and stakes it off, and he talks to his adjoining owner, and the adjoining owner doesn't say anything about it. He says, "Oh, you're building a wall, okay? And I see you've got it staked out here." And there's a little bit of bad blood between these two. And after he doesn't say anything or make any complaints about the wall, he goes back to the house and laughs because he knows where the boundary line's at. And he's waiting for this wall to get built to go over and tell his neighbor he's going to tear it down. Well, he's going to be stopped from doing that because your silence, when you know that your joiner is going to expend significant funds along the boundary line, and you have reason to know, and sometimes the courts will burden a landowner with knowing where his boundary's at. And when you don't speak up, then you may be forever silenced by the court. And the estoppel there becomes the boundary line effectively then.
Absolutely. Thanks, James. Kyle threw into the chat here, if a county or jurisdiction allows their GIS, Onyx, Land Glide, etc. to become prolific, and it becomes relied upon enough and no action is taken to correct a boundary, is there a case to be made that GIS line is a boundary line by estoppel? At some point, if enough people ignore the disclaimer and build based on these apps, is there a legal basis for this argument? Yeah, that's a good question. It's interesting too. Even building without a survey. Let's say it's a smaller, more urban lot, right? They're often just pulling a deed and plotting it, or pulling a GIS map because you can download that GIS data and placing their house on that, assuming that boundary is correct, and it may not be. I don't know. I think we'll see a bit of that coming over the next few years, and TK kind of mentioned that as well. So, great question, Kyle. Okay, well, welcome to the new year, everybody. Made it through chapter 5, on to chapter 6 here. And we're meeting in 3 weeks, right? We're meeting at the end of January now?
January 29th, yeah. That'll work out perfect. And then it'll be like back-to-back weeks. So January 29th and then February 5th. So, and then we'll go to like the end of the month in February because so many conferences and stuff like that. We're going to be bouncing around, I think, kind of until mid-March. So,
hey, pay attention to your emails, guys.
yeah, exactly. I'll keep it up, but.
Okay, thanks everyone. Have a good night. And Teresa threw something else in the chat there real fast. To establish a boundary by estoppel, the defendant must have silently looked on with the knowledge of the true boundary, while the claimant encroached on defendant's property or subjected himself to expense he would have not incurred had the boundary line been in dispute. Estoppel requires knowing silence on the part of the party to be charged and unknowing detriment by the other. There's an argument said that a GIS map is due notice, and if you don't say anything, knowingly don't say anything.
Well, I was just reiterating on James's point because I've seen that in Minnesota where somebody tried to do that, and just because they remain silent does not, they knowingly knew what the guy was going to do.
Yep.
I mean, that's crazy.
Yep.
I agree with James. It's not a good way to go about, being a nice neighbor.
Exactly.
Right, exactly. Okay, have a good night, everybody. Thank you. Great discussion.
Bye, everybody.